Hello and welcome to Friday Live. I am your host, strata lawyer Amanda Farmer. It is Friday afternoon. We have all had a big week in strata, a big few weeks. For some of us, it's been a little while since I've been here live with you. Lots of catching up to do. That's what we're here to talk about. How has your week been? Maybe a little bit wet and rainy where you are. The rain finally arrived where I am this week, which for us has been welcome. We've needed some rain here. Just a couple of days though, and now the sun is back out again. So I hope you're all doing okay if you've had a little bit of a deluge where you are, and I hope you have been keeping well. We do have a bit to cover here today. I plan to be here for around about an hour for your Friday afternoon. If you are coming in live, I'd love to see your hellos. Great to catch up. Great to see you here. If you're catching the replay, I like to see those as well. Happy to swing back around and say hi to those of you who are catching the replay. We are today going to give a nod to this week's podcast episode. I'm going to share with you a post that I put out on a couple of our social channels that got a few people talking, got some attention and some discussion. And I know there's a few opinions, no doubt, including from those who are tuning in, that you'd like to share with me. I'd love to hear from you. And I have a case for you today, a pretty juicy one covering lots of different things in strata. I was having a read of it a couple of days ago and I was marking it up. I was highlighting it as I like to do. And I thought, oh, that's a good point. That's a good point. There's another good point. I think the Friday afternoon crew would like to know about this one. So I am going to walk you through that case as well. Here you are, coming in ready to go. Petra, good afternoon to you. Kristen saying happy Friday and thanks for the membership content this week. Yeah, Kristen, I'm glad you appreciated it. What went out to our members this week was my template bylaw for CCTV, for an owners corporation's installation and management of CCTV. Not just management of the equipment, but management of the footage as well. How does an owners corporation give its owners access to that footage? How does it keep and store that footage? How long does it store it for? It's something that I've been asked to do for a while now. Amanda, have you got a template on CCTV, template bylaws? That went out to our members for their use this week. You might hear a little bit more about that in our member content update over the weekend. Sean, hello to you. Sean is coming to Mudgee tomorrow for a Sunday wedding. Oh, I'd love to hear more about that, Sean. Well, you know, the sun is out. I went outside today, actually did. I was sitting at a cafe enjoying the sun after a couple of days of rain and thinking, oh, the tourists are arriving. They'll be happy for this weather. Josephine, hello. Hey, Gail. Georgina, happy Friday to you. Christine joining us from YouTube, I think. Hey, Christine, how you going? Hey, Zita, David is here. Dr. Nicole, hello to you. NJ, Kristen saying, and the podcast as well. Enjoyed the podcast. Awesome. All right. So thanks for that tip off there, Kristen. I am about to remind us all about this week's podcast episode number 451. Rena and I having a chat, as we like to do from time to time, covering off our wins and our challenges for the week. And Rita had a doozy this week, didn't she? She was telling me about an owner who also happened to be the former building manager for a building who lives on site and decided that he wants to connect his hose, his water pipe to the common property tap. Had built quite an intricate system there to make that happen, pipes along the outside of the common property wall. Owners Corporation had locked the tap, I believe it was, because that was the easier option than removing all of that pipe work. And that owner decided that they'd get out their power tools and cut the lock off the tap and continue using the Owners Corporation's water. What do we do about that? was Rena's question for me. So we unpacked that one in the podcast this week. If you've had a listen, maybe had a little bit of a smirk about that one, strata managers, owners, one of the descriptions that I used in the podcast when I sent out the email was cowboy owners. Those words came out of Rena's mouth. Sometimes we have owners who do act like cowboys, do what they want, think they can do what they want in the building. How do we handle those cowboy owners? That was part of our discussion in this week's podcast. Also, I was sharing the story of an owner who has fought for more than a decade to get justice for his leaking, uninhabitable home, and letting you know that after that 12 odd years of having to deal with a leaking and ultimately uninhabitable home, he is ready to return. The work has been complete, or it is almost complete, and he is moving back in finally, not without his share of trauma over the past many years. We're going to talk a little bit more about that today, particularly as we look at this case that I'm going to take you over to, what some strata owners have to go through to get justice, to get compliance with the law. It is appalling to me that owners have to do that. And when I'm involved, they're often paying me as well to help them. So they're also having to shell out tens of thousands, if not hundreds of thousands of dollars in legal fees to get what they are entitled to. And I hear you. You tell me all the time. You're in my inbox. You're in our Facebook feed. You're sending me messages. This isn't right, Amanda. The system is broken. It is these cases that evidence that broken system. I'm with you. Absolutely. Philip, how you doing? Saying, with the podcast, the main question, if the owner's corporation removes the unapproved pipework, can the owner's corporation charge this cowboy? There are a couple of ways, Philip, that an owner's corporation can recover its costs of doing work. We do have a provision in our legislation in New South Wales about work that might be done by owners, where the owner's corporation has to come and intervene and may be able to recover its costs. Maybe the owner's corporation has a bylaw in place that allows it to recover its costs, a very carefully drafted bylaw it needs to be these days to make sure that it is valid and it allows that cost recovery. But ultimately, owners' corporations probably need to be going to the tribunal or, at the end of the day, a court to get their costs recovered. It's getting increasingly difficult to charge back owners, especially if owners know their rights and know that an owner's corporation can't penalize them, can't fine them, can't just decide on a figure that they want an owner to pay. An owner has a right to go to a court and have that amount determined as reasonable. So it's the kind of thing that now, this came up in our forum, in our members forum just this week, actually, and I was telling a member, look, this is the way I see it and what I think, but it's a really good idea for that owner's corporation to get legal advice before it heads down that path of on-charging owners for costs. There's a lot of considerations now to be borne in mind for owners corporations who want to do that. So also on the podcast episode this week, Rena and I were talking about a settlement that was reached between a lot owner and an owners corporation before things got out of hand in NCAT. That was about an insurance claim, or an insurance claim that an owner wanted their owners corporation to lodge. Owners corporation had initially refused to lodge that claim. Lot owner went off to NCAT seeking an order, and ultimately that case was settled. Tune into the pod to hear more about that one. And Capital Works Fund planning. I had received a question about, Amanda, what does a healthy Capital Works Fund look like? How much money should we be raising to our Capital Works Fund if we're buying a property and we're looking at the financials? How much money should be in the Capital Works Fund? My answer to that, how long is a piece of string? I don't know. There are so many factors to bear in mind when we're looking at whether a buildings fund is healthy or not. how big it is, how many facilities it may have, what amenities it may have, what capital work is done in the past, what is coming up, how old the lift is, how old the roof membrane is, how old the windows are, when was the place last painted. So many different considerations. Your 10-year capital works plan is a good place to start for the answer to that kind of a question. But as Rena pointed out, some of these plans might now be out of date because we have far more onerous requirements now on our buildings in New South Wales. We have the Design and Building Practitioners Act making a lot of our remedial work much, much more expensive than it was ever forecast to be. So a good reminder in this week's pod for strata managers to be letting their buildings know about that when they're reviewing or thinking about reviewing their 10-year plans. Hey, we now have this legislation that is leaving us with far bigger repair bills than we anticipated. It might be an idea to DBPA test the 10-year plan. So that is podcast episode 451 this week. If you've missed it, there's a link here that Rochelle has popped into the comments to check that one out. Catching up on some client work this week. As many of you, I think, know, or those who've been around for a little while know, it is a bit of a rule in my legal practice these days that I only act for lot owners. I don't act for owners' corporations. So what that means is I'm often sending letters to strata managers. I am opening up that line of communication, letting them know on behalf of their client, owners corporation, that the lot owner has engaged me, that the lot owner has a particular concern. Often, yes, that is about a failure to repair and maintain. It might be about a leaky ceiling or leaky windows. And I'm sending that first letter off to the owners corporation, care of the strata manager, letting them know what the problem is and what my client would like them to do about it. I did just that this week, sent off a letter to a strata manager, and the response that I got to that letter, it was an email with a PDF letter attached. The response I got to that email prompted me to post something on both LinkedIn and here on Facebook. If you haven't seen it yet, it is here on the page, but if you haven't seen it yet, what I'm going to do is share my screen here with you and show you the post as it's appearing, or as it was appearing around about this afternoon on LinkedIn. Here's what I said to the strata manager who replied to my letter today with these words: I confirm receipt of your letter. This has been sent to the committee for instructions on next steps. Yes, I say, yes, that is the correct professional response. When I get a response like that from a strata manager to my opening shot across the bow, my opening letter to them, they haven't heard from me before. This is the first time they're hearing that I act for a particular lot owner and we want the owners corporation to be doing something. When a strata manager writes back promptly with words to that effect, we confirm receipt of your letter. I've sent this on to the committee for their instructions on next steps. Might say, when I have those instructions, I will respond to you. My heart is full. I think everything is right in strata land, and I feel very proud of our strata managers. Yes, that is the correct professional response. Even better, my post goes on to say extra credit this strata manager gets if, when they forwarded my letter onto their committee, they didn't just say FYI. Now, look, bit tongue-in-cheek, I hope nobody is saying no strata manager is when they forward lawyers' correspondence onto their committee. I hope they're not saying FYI. But I know from seeing these emails from my clients' personal experiences, I know that some strata managers, when they get an important piece of correspondence, whether it's from a lawyer or it might be from a contractor or it might even be a complaint from an owner, when they're forwarding that onto their committees, sometimes, too often I think, they are simply saying, please see attached, please see below, FYI, maybe, we have received the below, attached for your attention. And that's it. The manager doesn't say anything else, does not take that opportunity to display, to exercise, to show the committee their skill as a trusted professional advisor. What am I getting at here? When a strata manager is forwarding on some correspondence to a committee that requires a response, that is inevitably going to raise questions, that is a letter from a lawyer and the committee is going to be alarmed about that, or is a complaint from a lot owner and owners are going to be alarmed about that, the strata manager, in my view, needs to be giving some advice, needs to be giving some guidance, needs to get on the front foot and anticipate that there will be questions, anticipate that please see attached, please see below, FYI is not going to be enough. Let's get on the front foot and suggest some next steps for the committee. And you can see those 3 ticks there on the screen. Here's some of my suggestions. The strata manager could say, I suggest we convene a committee meeting to consider next steps. Or would you like me to obtain quotes from strata lawyers who can assist with this? This looks like it's going to be a new legal case. Amanda's here telling me she acts for a lot owner. They've got a legal claim. Would you like me, committee, to obtain quotes from strata lawyers who can assist? Or even if it's something straightforward that the strata manager knows the answer to, maybe some documents are being requested, some facts need to be confirmed. Maybe it is a complaint from a lot owner that can be knocked on the head pretty quickly. Here is a draft response for your review and approval. There is nothing worse, I say, well, there's a few things that are worse, but it is particularly frustrating when, as a committee member, you receive an email from a strata manager saying, please see attached. We've received this correspondence. Please see attached. And as a committee member, you have to write back to the strata manager and say, thank you, strata manager. What do you suggest we do about this? If you're an owner, if you're a committee member finding yourself doing that, that's a great way to train your strata manager. This is what we expect. Don't send me things don't send me correspondence that says, please see attached. Please give me your advice, give me your professional opinion, give me your guidance, give me the next steps when you are sending this on to me. It is such a golden opportunity to display your expertise, to showcase that value and to bring that value that you have as a strata manager. Short story, don't be a post box. You're not a post box. You're more than that. And I just, in my time, 20 plus years now, I have seen that far too often. And some of the comments on LinkedIn, on Facebook, are echoing this. Strata managers are not just post boxes, recognizing that this is a step up that some strata managers need to make. But as we're seeing from the emails that I'm receiving, many strata managers are already there, and well done. Well done to them. Key point that I'm making here in this post, strata managers act on instructions. They are not the decision makers. So when there is an action that needs to be taken upon receipt of correspondence, it is incumbent upon, it is necessary that the strata manager sends that on to the committee, absolutely, and seek their instructions on the next steps that they want you as their agent to take. After years in legal practice, I'm still surprised by how often this distinction is missed or misunderstood, that the strata manager acts on instructions. I've encountered a few strata managers in my time who don't seem to get that. And instead of getting the response, Amanda, thank you for your letter, I've sent it on to the committee, I'll let you know when I have their instructions, I've received alarmingly fast email replies setting out all the reasons why my client is wrong and clearly didn't brief me properly. And I say alarmingly fast because when those replies fly back into my inbox 5 minutes after I sent the letter, I'm thinking to myself, there is no way that strata manager took instructions before sending me that reply. That is a reply that they have written in their own view, of their own volition, without seeking their client's instructions. And as a lawyer, where I also always act on client instructions, that just makes me feel a little bit ill. Phone calls asking, Amanda, how are you? So-and-so strata manager. It's great to see you online the other week. Love what you're doing with the podcast. Look, got this letter from you. Oh, surely we can sort this all out. We don't need to do this back and forth. You know, Amanda, I'll tell you what's really going on here. I'll tell you what's really going on with this owner. This owner's out of control. Amanda, this owner is out of control. You don't know the half of it. I've been managing this building for the last 15 years, and this is what they've been doing, and you're not the first lawyer to be involved. Oh, my goodness. When a strata manager calls me and speaks to me like that, I feel very sorry for their owner's corporation client. That is not how you speak to the opponent's lawyer. When I'm acting for a lot owner, I am not your friend. I might be your friend when we catch up at a social event, at a conference. I might be your friend here on live, on the podcast, in the membership. Unfortunately, I'm not your friend when I'm acting for a lot owner and you are the strata manager engaged by the owner's corporation. It is very likely that we are going to end up, if we aren't already, being adversaries. Certainly my client and your client being adversaries. So be very careful about starting a conversation with me like that when I have my lot owner lawyer hat on. Perhaps worst of all, silence, complete silence. I hear nothing in reply to my communication. And I think, I don't know if I got the wrong email address. Nothing bounced back. Has that strata manager been on leave? Are they sick? Is there a new strata manager? Have I sent it to the wrong place? We have a procedure in our office that will diarize to follow up, at least in a couple of weeks. We follow up, and then finally we get a response. Oh, please resend it. Never got it. It was lost. It was forgotten. I'm now seeking instructions. The ball has been dropped there for sure. So the point of my post, quick reminders for our strata managers. When a lawyer is writing to you on behalf of a lot owner, outlining a claim against an owner's corporation, your client, the owner's corporation, they are not your friend or your ally. Your client is the owner's corporation. It is your job to protect them, not to help out that lawyer, not to make life difficult for that lot owner. Your personal opinion is irrelevant and should not be relayed to the other side. I don't care what you think as the strata manager. What I care about is what you are instructed, what your client thinks. Your professional advice is valuable. Don't forget to give it. It's a great opportunity when you're dealing with third parties and they're making claims, they want things, and you're going back to the committee to request those instructions to display your expertise, to showcase it. I've said, do that to the person who matters most, to your client. You don't have to display it to me. You don't have to tell me about your knowledge of the law, why my interpretation of Section 106 is wrong and your interpretation is correct. That's your opinion. Seek instructions from your client. And if your client instructs you to assist them to engage a strata lawyer, then even better. Then your client can be giving instructions to that strata lawyer, and you don't need to get involved in that process unless your client requires you to. So you can see that post got a lot of interest there on LinkedIn. You can head over to my LinkedIn profile if you want to read some of those comments there as well. A very important point that was raised in response to that post, and I think it first came up from Michael Tees. Amanda, what about delegated authority and strata managers who have full delegated authority? Is there a question mark there about whether or not those strata managers can respond without instructions? And if they can, are their clients aware that they can, that they're doing so? And is everybody okay with that? Excellent point. And I did respond to that one. And there are a few more posts along those lines there under the LinkedIn post. The fact is, if a strata manager does have full delegated authority, it's quite likely that, yes, they can legally respond without seeking instructions from the committee. Should they? No. That's my short answer. No. Why would you put yourself on the line like that as a strata manager? And as I've said in reply to Michael's comment on the post, I will be forever flummoxed by strata managers who agree to take on full delegated authority. It is such an exposure to risk for you, in my view. And it's a bit of a lose-lose, because if you do have full delegated authority and you can go about and do many things for your owners' corporations without seeking instructions, when your client realizes this, when owners realize this and start to question it, they don't understand why you're able to do it, how you got this full delegated authority. No one's reading the strata management contract when it's approved at a general meeting. And all they can see is a complete lack of transparency. So while it might be legal, is it the right thing to do? Is it a great business decision? I don't think so. I think it can put you in a difficult corner to get out of. We saw a little bit of this. We've seen a little bit of this in the last 12 months, where our media has been making certain accusations of strata managers. Those strata managers have been saying, hey, not doing anything illegal. Doesn't really fly when you're talking to ABC News, not really doing anything illegal. So be careful about full delegated authority. And even if you do have it, I was on a education session with a group of strata managers the other day, and I said, even if you do have it, still a really good idea to seek those approvals, seek those instructions. Okay, a few comments here coming through as I have been sharing that post with you. Luke saying, so spot on. Not sure what that bit was about, Luke, but I'll take it. Thank you. Good to see you. Hey Chu saying good afternoon. Ready Strata Management saying there's never a correct answer as to how much should be retained in the Capital Works Fund, but a very broad range estimate could be advised as about 10% of the insured value of the property. Oh, okay. Yeah. All right. I like that. Ready Strata. Thank you. Kristen saying, oh, but strata managers do that with no advice to their strata committee. Yes, just forwarding things on there, Kristen. It's one of my pet peeves. It's one of my pet peeves. And if I am ever, as a committee member, on the other side of that, I do go out of my way to train, to assist in training the person who has just sent me that correspondence. FYI, please see attached. We have received the attached. Dear committee, we've received the attached. I make a point of writing back and saying, thanks for sending that on. What do you suggest we do about that? Even though as a strata lawyer, I might know what it is that we do about that. I think it's important to set the guidelines, set the expectations. This is our expectation as a committee as to the service you will provide as a strata manager. Zita is asking a question that's not quite on point today, so I'm going to move on from that one. Danielle saying, we've been trying to get lawyers' advice since August last year, on to our second lawyer now, and nothing in 7 weeks. You guys are busy. Yeah, absolutely. There are not enough strata lawyers, Danielle. I'm sorry to say, not enough. I've got a 2-month wait list in my practice. And as I said, I don't act for owners corporations. So every day my team is turning away committees and strata managers who are coming to us seeking quotes for advice and saying Amanda only acts for lot owners. And we give a list of about 5 or 6 other New South Wales strata lawyers who we refer work to, sounding like they are backing up as well, Danielle. We're all meeting in Brisbane in a couple of weeks' time, which might have something to do with the reason why people aren't available. Everyone's taking a week off. It is our rescheduled annual conference for the Australian College of Strata Lawyers. We're all getting together in Brisbane, and I'm going to chat to my colleagues about that. And what is it that we can do with our college, our Australian College of Strata Lawyers hat on, to make sure we get the word out there that strata law is awesome. We need more strata lawyers. They're in demand. There's a lot of work out there, and bring across some young property lawyers into the world of strata. I know everyone is desperate for staff as well. Those bigger firms that employ lots of junior lawyers are always looking for good staff. Deepti, how are you doing? Saying, hi, Amanda, what do we do if they completely ignore emails or don't bother acknowledging it despite numerous follow-ups? Yeah, so if that's the strata manager ignoring you, Deepti, I always say to owners, if you're not on the strata committee, propose a motion at a general meeting. The general meeting is your forum to be heard. And if you propose a motion for a general meeting, the strata manager, if they're acting with the secretary's authority, they must put that motion onto the general meeting agenda. And it can be a motion. We've got some template motions in our member library to the effect that the strata manager acknowledges receipt of my letter dated ABC and answers the following questions that are in my letter. Very frustrating when you're sending letters that aren't getting any further than the strata manager's inbox. Of course, again, as owners, you are also entitled to access a copy of the strata roll, and then you'll have the contact details for all owners. So if it's correspondence that you are wanting to get out to all owners, then that's another way to do it. Hey, Nathan, how you doing? Ready Strata saying a good strata manager should provide guidance and advice to the strata committee. The committee does not need to agree. They just need assurance that the strata manager's advice is impartial and based on their knowledge and experience. Yep, nailed it. Leonie saying a person I know in strata has told me they have no breakdown shown on levies of capital works fund and admin. That is interesting, Leonie, especially as our legislation requires separate estimates of contributions to admin and capital works fund. Okay, Sean jumping in there. Awesome. So that is what I wanted to say about that topic in our social feeds this week. Seems to have touched a nerve, perhaps articulated something that many people, both strata managers and owners alike, can relate to. One of those rare topics where we have strata managers and owners agreeing. Managers saying, yes, I've seen that too, and that's appalling. That's not how I conduct myself. Owners saying, yes, I've received those emails. That's really frustrating, or I have a strata manager who doesn't act on instructions. That's really frustrating. I am, as our audience grows here on Facebook, on LinkedIn, generally, I receive lots of messages. I get lots of messages through my LinkedIn inbox, messages here on Facebook, public messages here on the page. And sometimes those messages say things like, Amanda, you're only in it for the strata managers. We thought you were an owner advocate. You seem to be supporting strata managers. I'm not sure I'm comfortable with that. Then the very next day, I'll get a message that says, Amanda, I'm just really frustrated with all of the strata manager bashing that's going on here. And I think, right, not sure I can work this one out. What I do on these public platforms, on the podcast, absolutely inside our membership, is I speak to what I think is fair, what I think is right, and what I think is best for strata as a whole. I'm not on the side of the owners. I'm not on the side of the strata managers. It's a bit trite, but I'm on the side of strata and strata living. How do we improve this space for everyone? So please know that if you're hearing me one week criticizing strata managers, it's because, in my view, something's happened. Someone's done something or hasn't done something. There's been a case, there's been an email, there's been a media report where there is due criticism, deserved criticism of strata managers. Please know that the next week, where an owner has done something, a cowboy owner has done something, ripped a pipe off a wall, behaved badly, decided to become a tyrant in their own building, please know that there will be criticism of that kind of behavior as well. I'm not on anyone's side. You want to ask me, Amanda, whose side are you on? I'm on the side of strata. Fairness, what is right. I could say what is just, but as a lawyer, we try to stay away from that, because what actually happens in our courts and tribunals is a long way from what people might describe as just, but that's the line I'm going to walk. So if you'd like to send me messages saying, Amanda, we think you're on the side of the owners, or we think you're on the side of the strata managers, please do feel free, but also know that I'm not paying too much attention to those ones. All right. We are going to move in to our case for today. I will share a copy of that case on my screen with you, and we also have a link to it for you. It is a case that, like my social posts today, has a few lessons in it for strata managers. I am going to walk you through it. We have a public access copy of the case, and then what we also have is a members only copy. And the members only copy, as you asked for, my dear members, the members only copy has the highlights in it, the highlighted sections in it that you are going to see on my screen now. So where I have previously read the case, marked it up, highlighting the important bits, you've told me previously, Amanda, can we get a copy of that highlighted copy of the case so we don't have to read the whole thing if we ever need to go back to it? We can just look at the highlights. Yes is the answer. For our members, you have access to the highlighted copy. And I believe Rochelle has popped in for you into the comments here. She's quick. There they are. She is quick. Where you go in our member forum to access the highlighted copy of the case, that forum link will take you to our case spreadsheet. And you will see, I think it's going to be at the bottom of the list. We might flip that list, Rochelle, so our more recent cases are at the top. At the bottom of the list, you will see this case, and you can click through to get the highlighted copy that I am now going to share with you on the screen. What is this case? It is a December 2024 case, which I only just got around to reading this week. It is the case of G, I'm going to say. I'm sorry, please correct my pronunciation there. G and the owners of Strata Plan number 90024. A decision of a single member of the tribunal. Ultimately, the successful owner obtained an order for the appointment of a compulsory strata manager. Section 237 order appointing a compulsory strata manager for a period of 12 months. Not all that controversial in itself, not all that unusual these days in my experience. What I found interesting about this case is some of the complaints that the owner was making about the conduct of the strata manager, the conduct of the owners corporation as a whole, recognizing that the strata manager was carrying out the instructions of the committee and the majority of owners. There are some lessons to be learned here, and a couple of things we've been talking about over the last 12 months about what the law means, what some new provisions in our law mean, coming to light here in this decision. So let us work through this one. I'm going to scroll on down to the highlights. These are the highlights that our members will have in their copy of the case. This decision deals with an application by the applicant for the appointment of a strata managing agent to the owners corporation. And to be clear, that is an appointment under Section 237, a compulsory manager in the role of an administrator, having all powers of the owners corporation and the strata committee for a period of time. So owners lose their voting rights, owners lose their control over the building because the building is just so dysfunctional that it needs this administrator to come in and fix everything up. That is what the applicant was seeking in this case. That is what the applicant got. Both parties represented by lawyers. There was a bit of discussion. There is a bit of discussion here in this decision about some procedural matters at the beginning, witness statements, whether the witnesses were called for cross-examination, whether the statements were relied on. I haven't highlighted any of that because it's not all that relevant to what I want to share with you here today. So I'm going to scroll through those first few paragraphs. This is a strata scheme that comprises 120 lots. That is relevant. It is relevant because it makes the strata scheme a large strata scheme, more than 100 lots. And so there are some particular provisions that apply to this large strata scheme. The applicant is the owner of one of the lots. There was, for most of the period about which the applicant is complaining, there was a strata manager in place. That strata manager was PSMG. And you'll read in this decision, the strata manager who's the licensee in charge of PSMG is Whitney Wang. These names might sound familiar to you. There has been a little bit of media about Whitney Wang and PSMG over the last 12 months or so. This is, I want to acknowledge straight up, a strata manager whose license was cancelled by Fair Trading back in July 2024. That decision to cancel the license of both Whitney Wang and PSMG Group, that decision was appealed. And you guys let me know if I've missed anything, but as far as I know, that appeal has yet to be determined. So the cancellation has been suspended for the time being. So that is all I'm going to say about that one, but just recognizing, Sean M's already there saying, oh, PSMG. Yes, I thought some may recognize the name. So this is a building that, at least at that time, was being managed by PSMG. And as of March 2023, there was a deficit in the Owners Corporation's administrative fund of $74,000. So that fund was showing as being in deficit. When we have one of the funds in deficit, but we're still able to operate, to be solvent as an owners corporation, it is essentially because money is being borrowed from the other fund, from the Capital Works Fund, to pay expenses of the administrative fund. This is relevant in this case because the tribunal ends up being critical of this, and particularly critical that the fund was in deficit for a considerable period of time and regularly in deficit, and there was no attempt made to correct that deficit. And there is a requirement in the New South Wales legislation that such deficits be corrected, or where money is borrowed from one fund, Capital Works Fund, to pay the expenses of the other fund, then there are resolutions dealing with whether or not that fund should be repaid, whether the Capital Works Fund should be repaid, not what happened in this case. In May 23, members of the Strata Committee identified what was said to be issues with PSMG's management. There were financial and accounting irregularities that the applicant referred to, including alleged overpayments to the building managers. Wealth Group Australia Proprietary Limited was the building manager. And I believe what it got down to is that there was an overpaid amount, or at least the applicant said there was an overpaid amount to the building manager of about $15,000. There was a consensus that Wealth Group Australia had been overpaid. So I think eventually the strata manager and the committee, through communications from the applicant, came to understand and see and agree that the building manager had been overpaid, but it wasn't without its many back and forth emails. And I see this a lot. I see owners who are frustrated by what they see as obvious irregularities in the financials. I have a client at the moment who has pointed out consistently to a strata manager that certain invoices have been paid twice. And she's pointed that out, had to point that out 3 times over before the strata manager, or perhaps I want to acknowledge the committee giving instructions to the strata manager, accepts that this is actually an error in the accounts. These errors happen more often than I would like to think, than I would have thought. 20 June 2023, there was an in-person general meeting held to address issues with the management. A resolution was passed at the meeting to terminate the strata manager. Now, there was a real question at that time over whether the Owners Corporation had the right to unilaterally terminate its strata management contract. This was a contract that wasn't at the end of its term. There was likely, if it was the standard SCA contract, a provision in there that allowed for mutual termination, but the strata manager did not agree to terminate, and it wasn't open to the Owners Corporation to just say, we're done, we are exiting this contract. There was also an allegation from the strata manager that the meeting that was held in June 23 was invalid because it didn't comply with meeting protocol, strata manager's words, stipulated in the Act. The owners who sought to convene that meeting didn't have an up-to-date strata roll, so it was hard for them to know where to send the meeting notices. It was submitted by the Owners Corporation ultimately in these proceedings, when they were trying to avoid a compulsory manager, that the meeting couldn't deem to have been convened in accordance with the Act. perhaps because the notices weren't sent to the right place. Another problem that I see owners struggling with poor strata management up against is that they cannot get access to records. I think Deepti said it earlier. We can't get access to records. We can't get communications acknowledged or circulated. So it makes it really hard for us to cure problems, to act outside of the strata manager, to do our own thing, to convene our own meetings, because the strata manager, who's the source of the problem, is the custodian of these records. And we ask for them, things like the strata roll, they don't get produced, then it's very difficult for us to hold meetings to try and solve problems. Totally get that. In June, the strata manager sent out a notice of an annual general meeting to be held. There was a dispute about who should be chairing that meeting. Another complaint that is not unfamiliar to me. The strata manager gave evidence saying that I occupied the role of the chairperson of the Owners Corporation at the time. I believe I was entitled to exercise the functions of the chair and to ratify the attendees. The meeting actually had a lawyer attending on behalf of another lot owner, and the applicant went and had a chat to that lot owner. The applicant was the chairperson, and the applicant said to that lawyer, I want to be the chairperson of the meeting. The strata manager said, no, I'm chairing this meeting whether you like it or not. But when the applicant went and spoke to this lawyer, the lawyer said, no, you are entitled as the chairperson to chair this meeting. It was clear to the applicant during the exchange that the strata manager would not permit the members of the strata committee to chair the meeting or to allow the meeting to occur without their involvement. Example here of a strata manager who, for whatever mixed up reason, will not let go of control of this owners corporation and doesn't understand the law. The law being that, yes, if the chairperson is present, that person, elected chairperson of the committee, that person is to chair the meeting. The strata manager may have delegated authority to chair the meeting, but that does not trump or replace or override the actual chairperson's authority to chair the meeting. The strata manager was wrong in this argument. During the meeting, there were heated and aggressive exchanges leading to the management of the venue, which was the club at Ashfield, directing the participants to leave the venue and the meeting ending abruptly. This is not the first time we're hearing about difficult meetings in public places. We've seen this splashed across the media recently. We've seen a strata manager who has just been banned for life because, among other things, of misconduct during or inappropriate, I'm going to say, conduct during a meeting that was captured on video and then broadcast on Australian media. We can only imagine a similar situation here in this public place where if you read the details, security guards being involved in this meeting, the meeting ending abruptly with the management of the club directing participants to leave. The meeting was not properly closed or adjourned, and there was another meeting convened. There is just no excuse for that to be occurring in our strata context. No excuse, no reason why people should be behaving in such a way that causes a meeting to have to conclude because of people can't be controlled, and especially in public places. It's just an embarrassment, in my view. Continuing on to further findings of the tribunal, the tribunal member found that 10 lot owners who did not have an email address recorded on the strata roll did not receive notice of one of these meetings. So there were quite a number of meetings going back and forth. 10 lot owners did not have their email address recorded, so didn't get notice of one of the meetings. The deficit, as at the 10th of April, in the Owners Corporation's admin fund was over $100,000. I mean, I think that's huge. So, strata managers out there, 120 lot building, admin fund deficit of $104,000. How does that happen? And a new managing agent was appointed to the Owners Corporation in November 2024. And I think that was because the PSMG agreement came to an end. Moving on to more of the tribunal's findings. Under the agreement between the Owners Corporation and Wealth Group Australia, that was the building manager, the Owners Corporation agreed to pay on an annual basis $23,000 plus GST for building management services and $76,000 plus GST for cleaning services. Now, this is where we get to Section 102 in our New South Wales legislation that requires two quotations to be obtained, two independent quotations to be obtained for any item of expenditure over $30,000. That didn't occur in the case of the Wealth Group Australia engagement. The Owners Corporation acknowledged that two quotations should have been provided. The tribunal found that the Owners Corporation did not comply with, I think that's a typo, I think it's Section 102, in respect to the expenditure for cleaning services under the contract. The Owners Corporation made the submission that it was relying on the agreement being a continuation of the prior terms and conditions. It's a reappointment. This is important. This question has been asked before. How do we calculate this $30,000? What if we're reappointing the same strata manager or the same building manager? Do we still have to go and get two quotes? This is the tribunal saying yes. Yes, you do. Whether the contract was a reappointment or not does not affect the applicability of Section 102. We've still got to get those two quotes, even if we are reappointing our strata manager that we've had for 3 years, even if we're reappointing our building manager that we've had for 10 years, we need to go and get those two quotes if the expenditure is going to be over $30,000. That jumped out to me. I'm not sure that we have seen a decision that made that clear since we've had this amendment to Section 102, where it applies to all buildings, not just large buildings anymore, all buildings, this requirement to get two quotes. Also, Section 102 provides that an owners corporation for a large strata scheme must not spend on an item or matter an amount greater than the amount specified, so the amount budgeted, plus 10%. Large strata schemes, you can't overspend on your budget, but there is a 10% grace amount there. So if you just go over by 10%, then you're okay. Remember, this was a large strata scheme, so they had this restriction on their expenditure. And the applicant had pointed out there were a few items with expenditure exceeding the budgeted line items by more than 10%. Fire protection was $4,500 instead of nothing that was budgeted. Another item is cleaning equipment, $7,000 instead of nothing. Legal fees, $3,500 instead of nothing. The sums involved need to be put, said the tribunal, in the context of an admin fund budget of slightly more than $450,000 for that financial year. Tribunal says, having regard to the relatively small sums involved and the timing of the admission of one of the exhibits, I do not accept the complaints of the applicant founded on a contravention of Section 102. So this is important for our owners who, and you often come to me saying, Amanda, these things are happening in our building. These are breaches of the law. I think we're dysfunctional. We need to get a compulsory manager. And I think a compulsory manager will be appointed because of all these breaches of the law. Sometimes the little things are let through to the keeper. The tribunal says, look, yeah, okay, technical breach. But if you think it's a few thousand here, it's a few thousand there in a budget of nearly $500,000, I don't think it's such a big deal. So that's important to have a little bit of perspective about your heads of complaint, let's say. And sometimes some of these smaller complaints are not worth pursuing. You'll hear me, if I'm your lawyer, saying, let's focus on these 3 big ticket items and let's not muddy the waters with the little stuff. This is the reason why, because the tribunal doesn't necessarily want to hear about those smaller infractions. One of the applicant's complaints relates to the owners corporation's overspending of the admin fund, causing it to be in deficit. I am satisfied. said the tribunal that the owners corporation has, over an extended period of time, incurred admin expenses in excess of the funds available in the admin fund. So we're in deficit. I accept that the extent of the deficits vary, but I also note that it is even after the striking of the special levy, a deficit has persisted, and at times it is significant. So if you are consistently running a deficit, if that deficit is significant relative to your actual budget, then tribunal may find that that is unacceptable. That is a breach of your legal obligation to properly budget and budget for your expected, anticipated expenses and to raise levies in accordance with that budget. Deficits, if they exist, should be rectified promptly. That is my guidance, and that comes from the tribunal's statements of these principles here. Admin fund's been in deficit. When it's been in deficit, the funds attributed to the Capital Works Fund have been utilised. This has persisted for a period greater than 3 months. The owners corporation did not, within the 3 months, determine an amount to be levied as a contribution to the capital fund to repay it. I'm satisfied that at least in that period, there was a contravention of the Act. This refers to the old law, where if you were borrowing from one fund to pay the expenses of the other, you needed to repay that fund from which you were borrowing within 3 months. You now have a choice whether or not you repay, but I would certainly caution you on this authority from running any deficit for any extensive period of time. The applicant has a number of well-founded complaints concerning notice of meetings. I'm satisfied that 10 lot owners who had no email address on the strata roll records were not given a notice. In a scheme with 120 lots, 10 owners not receiving notice of an adjourned annual general meeting is not acceptable. I'm not sure if 1 or 2 owners would have been acceptable, or if the scheme was 500 lots and there were 10 lot owners who didn't receive their notice, that would have been acceptable. It seems to be relevant to this tribunal member that we had 120 lots, 10 people didn't get their notice. That is not acceptable. Another reason why this tribunal ultimately decides to appoint a compulsory manager. Now, this final point about disharmony was very, very interesting to me. And those of you who follow compulsory appointment cases and the reasons why our tribunal will make compulsory appointments, you might be surprised by this as well. I'm looking at those who are present and the names here. Some of you will be well versed in the history of these compulsory appointment cases. The tribunal member looked at the disharmony, the degree of disharmony among lot owners, and this became a relevant consideration. I've always said to my clients, doesn't matter that you don't like each other. It doesn't matter that you've got personal gripes. Doesn't matter that we have personality clashes. That does not make you dysfunctional. We need to look at breaches of the law. We need to look at whether bylaws are being enforced. We need to look at whether the insurance is being paid, are meetings being held. The fact that you don't like each other and there's just general disharmony is not going to be enough. And I think alone, it still isn't enough. But the tribunal made some really interesting comments here about disharmony. And I can see some lawyers in the future, in future cases where you have buildings with disharmony, perhaps referring to this now and using this case as a bit of a precedent. Where you have disharmony amongst lot owners, you might be more likely to get a compulsory appointment. Tribunal said, I find there is a degree of polarization among at least some lot owners. Of course, that does not mean the owners corporation is not functioning satisfactorily. However, the tribunal cannot overlook that in these proceedings, the disharmony and arguments, as at the famous Club Ashfield AGM, reached a level of severity that the venue's management asked participants to leave. The level of disharmony leading to abrupt ending of an annual general meeting is affecting the proper functioning of the owners corporation. So there you go. This polarization, this infighting that was going on, one faction wants one thing and one, to keep the strata manager, the other to sack the strata manager, ends up in a dust up in a public place, and the general meeting cannot go ahead. It has to be stopped. We've got security guards called in. Tribunal is saying if that affects the functioning of the owners corporation, if we're affecting the functioning of the owners corporation, the disharmony is going to be a relevant consideration here for me with this compulsory appointment application. Overpayments to the building manager. Tribunal ended up saying, remember I said there was about 15 grand overpaid to the building manager? Tribunal said that doesn't matter. I'm not giving weight to that because the issue appears to have been resolved. But note, it did involve an unnecessary degree of effort to explain to the strata manager. And on one view, the strata manager should have been more diligent, but the issue appears to have been resolved. The applicant owner finally got the manager to understand that there had been this overpayment. An exhausting exercise for an owner to go through. In summary, for the reasons discussed above, the following matters are a summary of the matters discussed which persuade me the owner's corporation is not functioning satisfactorily. Contravention of Section 102, we didn't get 2 quotes for that large item of expenditure, the building manager and cleaning contract. Regular deficits in the admin fund. Failure to comply with the provisions requiring notice of general meeting. So there were 10 owners who didn't get their notice. Their email addresses weren't right on the roll. There was conduct in respect to a proxy. Didn't bother going into that one today, but that's there for you to read. And the disharmony as described above. So for all of those reasons, tribunal decided compulsory manager should be appointed, and that manager was appointed for 12 months. 12 months is the appropriate length for the appointment. 6 months not sufficient. I imagine 2 years might have been considered too long, might not be in a building like this that seems to have a little bit of work to do to get its act together. Hopefully they will now be well served by their newly appointed compulsory manager. Lots of comments have been coming through while I've been sharing this with you. One that's just jumped out to me is Bill and Ben talking about paragraph 143. Yes, Bill and Ben saying, we like that. About time it held weight. Yeah, the disharmony. So yeah, good one there for the strata lawyers to be aware of and to rely on. So what do you think about that one? I've always got my eyes on compulsory appointment cases because I have a lot of clients who want to, a lot owner clients who want to go down that path. I am always very reluctant to lead them down that path. I have always said these are hard orders to get. The tribunal is more likely not to order a compulsory appointment than they are to. I think that's a good thing because they are very serious, removing powers, removing rights from owners to have a say in how their building operates for a period of time. But we've got a pretty good body of case law now to be able to measure, compare your situation against, and if you are going to be filing one of these applications to, I think, gain a pretty good idea of where you're going to land if you've got a good understanding of these cases. Okay. Heading over to those comments, I'm not sure where we left up here. Philip saying, I've been pondering how to fix strata managers. Oh, I like that one, Philip. And I came to the conclusion the remedy is to legislate management agreements, which can be terminated at any time. Then the slack on professional managers who treat owners' corporations as milking cows, not as if being an owner, will be quickly out of business. That's not the first time I've heard that, Philip. Not the first time I've heard that. Yeah. One to think about. You'll have strata managers out there saying, well, we invest a lot when we take on these contracts. Some of these contracts are hundreds of thousands of dollars contracts for big communities. We hire a person to help in the management. If it can be terminated at any time, it's going to be very difficult for us to commit to those kinds of contracts. That would be the response that might be put against you. But, all creative ideas on the table. Sean saying something determined this week about PSMG. Not sure. Let me know, Sean, if I've missed that. Let's not confuse PSMG with the other strata manager, Michael Lee, who has been banned for life. That was last week. As I think I said, some similarities there in these cases, that's for sure. John saying, why do some strata managers fight against the owners corporation? My understanding is that they support the owners corporation. Are badly behaved strata managers held accountable by any kind of licensing board? Great questions, John. All great questions. Why a strata manager, when faced with many, maybe if not a majority, but many owners who don't want them there, who don't appreciate, understand their management? Why those strata managers want to hang on to that contract is beyond me. I do not know. I do not know why. As for the regulator in New South Wales, that is Fair Trading. That is New South Wales Fair Trading. And probably 3 times this week, I have had a conversation either with an owner at the end of the phone in one situation, online in another, or within my team, to be saying, we are seeing far too much of this, what I've just shown you in this case. We're seeing far too much of this, of owners' lives being put on hold while they try to sort this out and call their strata manager to account. They have to, the applicant in this case, represented by counsel, by a barrister at the hearing, paying for all of that. It shouldn't be up to these owners to call out this, in my view, as somebody who knows the law, obviously illegal behavior, put at its highest, poor behavior, unprofessional behavior, mismanagement at its lowest. Why is it up to owners to call that out, to identify it, to go through this process, to put their lives on hold, often for many years? Our regulator, Fair Trading, should be equipped to receive these complaints, investigate these complaints, look at the black and white issues. These are not complex legal issues. What's going on here, wrong here, is very obvious, and to do something about it. This case has a little bit of a sting in the tail because this particular manager, Fair Trading, has done something about, has cancelled their license. This decision came down after the cancellation of that license. That strata manager has appealed that, and the license cancellation has been suspended. So that's a difficult circumstance, but it is an example of the many more cases like this that are going on out there. So I'm with you, John. Chu saying, does an AGM have to be carried out without inviting the strata manager? You don't have to have your strata manager at your AGM, Chu, not at all. You can tell them that they are not required. Why fight against the people paying them? Yes, indeed, John. Okay. Scrolling on down, Martin saying the problems of access to strata roll happens when the secretary and committee refuse access to the strata roll, and the managers maintain they can redact the information like contact details under the Privacy Act and threats that they have been sued before. So even with a strata search, you don't get access. Yep. Very common experience in our world, in our circles, in our community here, Martin, and a problem. And we have tribunal cases that say that's not on. It's not on. Redacting the strata roll is not on. Withholding records is not on. And it's frustrating that that message in some places is not getting through. Okay. I was wanting to get through all of these comments, but they just keep coming. So I'm going to return to those later on. Thank you very much for your engagement, your interaction, your questions. Keen to hear your thoughts, more of your thoughts when I can get through all of those comments. Great to be here with you this Friday. I think that's all I wanted to share with you. Oh, no, there was one thing. I wanted to make sure that our members are aware that early next week, hopefully Monday, if not Tuesday next week, there's going to be a members survey dropping into your inbox. We are looking at ways that we can improve, change up, refine what it is that you are receiving from us on the other side inside the membership. It's 9 years this year since we've been running the membership. I want to hear what you love, what you want more of, what you could do without. I want to hear from you what it is that makes our membership the place to be. Always looking to improve our offering for you. So keep your eye on your inbox, members, for that particular survey. Looking forward to collating all of those answers and taking us into next year, our 10th year of the Your Strata Property membership. It's been so fun. Lots more to come. Have a fantastic weekend in Strata, everybody. Stay dry, relax, enjoy, and I'll catch you all next time. Bye for now.